Right, the big one, guys. Landlord and Tenant Act 1985, Section 11 specifically. This is about a landlord's repairing obligations and is really, really important at the moment due to all of the legislation changes that have come into force, in particular the Deregulation Act. So I hope that all you guys in here know that it is your obligation to repair and maintain the structure and the fixtures and fittings of your property. Air, space and water heating. You should also know when repairs must be done and what is a reasonable timescale depending on urgency. You should also know that your tenant should act in a tenant-like manner. What is tenant damage and where does compensation for alternative accommodation come into play? So guys, in a nutshell, we as landlords, we have to make sure that we are repairing our properties when required. But under the Deregulation Act, what they've done is they've now brought in legislation that means we have to document every maintenance repair that comes in. How many in here are let-only landlords who manage the properties themselves? Please put your hands up. Quite a few of you. That's great. Every time your tenant reports a repair to you, you now must document when that report came in, what timescale you responded within, not got the job fixed, but what timescale you responded in, and you must keep all of that evidence documented throughout the entirety of that tenancy. One of the restrictions that they've put on this as well is that your response must be in writing. So really you need to be, even if you've had a verbal conversation, you need to be following up anything that you're doing via email, because a verbal conversation can be denied, and this really could stop you from obtaining possession under either Section 21 or Section 8. And Tanya, who works in our property management department, sat at the back there, has been recently putting through a lot of rent guarantee claims, because a lot of our landlords choose to take out rent guarantee protection. So where tenants fall foul of paying their rent, a claim is made. These are the key points that the rent guarantee insurers are now questioning. And they are requesting that we provide evidence of our response times and of the repair times that it's taking to get done. And if it hasn't been carried out in a satisfactory timescale, it could hinder when you get to court. So what they're trying to do is they're trying to prepare their case for when they get to court, because most tenants, the only thing that they can probably defend on a Section 8 rent arrears notice is maintenance. They can't turn up and say I've paid, because they're not going to have the evidence that they have. What they will do is, my landlord didn't fix this. What is likely to happen is your case will get at least adjourned, and you're then going to be waiting another 4 to 6 weeks before you can get back in front of the judge to plead your case. So for you let-only landlords, please make sure that you're documenting everything and that you are responding to your tenant in writing within a reasonable timescale. What is reasonable? This is the funny thing with these legislation. If it's urgent, it needs to be dealt with immediately. And I think a reasonable time for a response from a landlord is within 24 to 48 hours of a maintenance item being reported. Not necessarily being repaired or a contractor attending unless the matter is urgent, but most definitely 24 to 48 hours response time would be deemed as reasonable. We manage so many properties and we work with so many different types of landlords. You wouldn't believe the amount of landlords that actually don't respond. Rebecca there, sat at the back as well, works in maintenance, so this is her thing. Every day she's coming to me saying, Dawn, the other day, in fact, we had a major leak, huge leak. Couldn't get hold of the landlord, we've still not got hold of the landlord. No? No. A lot of landlords don't respond to these maintenance reports. And they're okay because we're responding on their behalf and we will take the relevant action that we're authorised to do. It's so important to make sure that you're responding. Tenant-like manner, what does that mean? A tenant-like manner means that tenants should be responsible for changing light bulbs. The funniest one we had so far, in fact, there's two funny maintenance reports we had. We had one where the tenant said, the light bulb needs changing, and the tenancy manager said, well, change it then. He said, but the light is on the ceiling. She said, most lights are on the ceiling, sir. If you get some step ladders, I'm sure you can reach and just change the bulb. And then the other funny one that we had, which was really quite funny, we had a tenant say, I have an urgent matter. There are some bugs on the outside of the property, and it is essential that you send somebody out to get rid of them before they come inside. Some of the requests that we get from tenants are just crazy and bizarre, and things that they can do themselves. So changing bulbs, changing washers in taps, repressurising the boiler if they've been given the instruction manual to do so. That's the key there. Tenant damage. What is a tenant's responsibility? Don't forget, you shouldn't be held liable for everything, but unfortunately in some cases, one of the cases that I'm thinking tenant damage, where you as a landlord would be responsible, however you would be within your rights to claim back the money from the tenants, is where, let's say for example, what did we have the other day? A tenant had left some tools on the shed and the wind had blown them off. It was a long time ago, not in this heat. But the wind had blew them off and it had smashed one of the windows to the property. Now, that is tenant's responsibility because the landlord didn't put the tools on the shed, and therefore, how can he be held responsible? However, he does have a legal obligation to ensure the security of his property, and therefore, he would have to carry out the repair to ensure that the property is secure, but would be well entitled to claim that money back from the tenant because that is tenant damage, it's tenant responsibility. Some other good examples about tenant damage and tenant responsibility is blocked toilets and drains, where they've been putting toilet wipes down there. Baby wipes, face wipes, and they just decide they're going to flush them down the toilet and it blocks up the whole thing. That's tenant damage. It's tenant damage if you've got within your tenancy agreement, so again, please review it, that they're not to be flushing anything other than toilet roll down the toilet. So, to ensure that they're not putting baby wipes or so forth. We had a deposit claim go through where a tenant admitted to putting wipes down the toilet, but they were biodegradable, and on the package it clearly said they were flushable. So her defence to the deposit claim was that she'd followed the guidelines on the pack and it said that they were flushable. However, remember what we've just talked about a contract. So the contract overruled what was said on the baby wipes pack because we'd clearly stated within our contract that you must not put anything other than toilet roll down the toilet. So therefore, the deposit was awarded in favour of the landlord for that bill. Makes sense, guys? Any questions about maintaining the properties and ensuring that you're keeping up to speed with the maintenance? For those of you that don't have any form of recording mechanism, I suggest you start, even if albeit is a diary or something that you can record the calls on.